Sad that we have to be here yet again to deal with government misconduct that is ruining the lives of families in Camden County. Today, we're talking again about the Sullivan case. Today, we filed a motion for speedy trial. It's a motion for speedy trial on behalf of Corey Sullivan, the Camden County Superior Court, where he stands charged with 2 serious felonies involving his child. We have filed that motion. We've also filed a motion to amend the bond conditions to allow him to have contact with his youngest child. The reason for that is, first, there's no evidence that a crime was committed. Second, there's no evidence that Corey Sullivan committed those offenses that are alleged. And what we find all too often is DFCS goes to law enforcement agencies who are not experts in these matters, particularly in smaller towns and communities. And basically, they selectively provide information about the children for the purpose of gaining an advantage in litigation. In this case, Mr. Sullivan can't maintain a relationship with his child because he can't be around this child. His relationship with the other children is also impaired. But the use of the criminal case is a way of setting him back. It's also a way of trying to pit family members against each other, usually mothers against fathers. And that has to stop. But what we see over and over again, and I have other cases like this, where DFCS gets the police to pursue criminal charges based on selective information and incomplete information. And then those charges sit for months and years without ever coming to court. Eventually they get dismissed. Why? Because when the district attorney gets a chance to look at the evidence and looks at the whole picture, the district attorney's office gets to see that there's really no case. But by that time, the family has been ripped apart and destroyed, and the children irreparably damaged, which is why we filed the speedy trial motion. In this case, on behalf of Mr. Sullivan, we believe that on further review and further consultation with the Georgia Bureau of Investigation, the district attorney's office will dismiss these charges against Mr. Sullivan. In the meantime, we're asking that he be permitted to have visitation with his child, as may be approved by the juvenile court of Camden County. Because the way this works now is the juvenile court doesn't have jurisdiction over the criminal case, and the criminal court doesn't have jurisdiction over the juvenile case. So effectively, the parent who's presumed innocent is deprived of access to his own child. And those are matters we'll be addressing in the Superior Court of Camden County. In the juvenile court, we have filed a joint motion along with counsel for Diana Sullivan for the dismissal of the DFCS case based on outrageous government conduct. Due process applies in these kinds of proceedings. That's not just a matter of common sense. That's a matter of fact. That's case law. One of the things that you can't do when you're DFCS is you can't conceal exculpatory information, favorable information from parents in the court in these cases. You can't withhold information favorable to the families. In this case, we have every reason to believe that there is, in fact, a CASA report that is favorable to the Sullivan family. And that report has never been furnished to the defense, and it has never been furnished to the court. What possible interest does the state have in allowing children to go forward without adequate diagnosis of their medical conditions? This isn't medical neglect that we're talking about here. This is deliberate indifference to medical needs of the child and of these children. That's just wrong. It's time for DFCS to stop playing games. And we talked about this at the last press conference. The DFCS caseworker in this case, as we stand here today, is still at work, still handling cases involving children. Probably still in there right now. Well, that's my understanding. The last time the media were here, he hid inside until after y'all left. Maybe he'll come out this time and talk about the way that he deals with the children in this case, the way that he deals with the witnesses, the way that he treats these families. Maybe he'll come out. We keep hearing rumors about he's no longer there or he's not going to be there. But as we stand here today, my understanding, he's still employed by DFCS and still handling cases involving children. This isn't right. We have an agency here in Camden County that is run amok. Something needs to be done about it. And we believe the court ultimately will grant the motion to dismiss. But we also believe that the individuals responsible for the tragic mistreatment of the Sullivans and other families in Camden County, that all of those responsible need to be held to account. The removal, replacement, retirement, whatever you want to call it, of one low-level staff person doesn't address the systemic issues from which this agency suffers from locally. And thankfully, the media have taken an interest in this case, as it has in other cases. And hopefully, with the continued interest, DFCS or the state of Georgia will eventually do the right thing and hold all of the workers who are responsible for the abuses in this case, all of them, to be held accountable, however far up the chain of command that may go.